Hello everyone, welcome to ASC Group. I'm CA Shikha Goel. So we are discussing today the topic related to ITC being blocked by the department on GST portal. So have you ever faced the issue related to ITC being blocked by the department on GST portal? How can we unblock it? Let's discuss it in detail. Under GST law, there is a rule called 86A of CGST rules 2017, which talks about the conditions where ITC input tax credit available as per electronic credit ledger of a registered person will be blocked by the department. Such input tax credit could be blocked by the officer of commissioner level or any other officer authorized by him not below the rank of assistant commissioner. Now we will discuss all these conditions where ITC being blocked by the department in detail. There are 4 such conditions pertains under Rule 86A. The very first condition is related to tax invoice or debit note. As we all know, we can take input tax credit in relation to a debit note or a tax invoice as prescribed under Rule 36. However, if the said tax invoice or debit note is being issued by a registered person who is a non-existent person or conducting business from a place which is not registered under GST, in that case, ITC will be blocked by the department. Further, if the goods or the services which is being mentioned on such tax invoice or debit note is not received by the recipient, then also ITC will be blocked by the department. So the first condition consists 2 parts. The first is where the supplier is not the genuine person, not the existing person, and the second where the goods are not being received by the recipient. In both these situations, ITC will be blocked by the department. In the second condition, it is mentioned that the said tax invoice or debit note in which taxes has been mentioned, if the government has not received those taxes, then also ITC will be blocked by the department. In the third condition, if the recipient is being a non-existent person or conducting business through a place which is not registered, then also ITC will be blocked. There are furthermore one more condition, that is condition 4, which says that if the recipient is not in the possession of the tax invoice or the debit note, then also ITC will be blocked by the department. There are 4 such conditions in which ITC can be blocked by the department. There is no compulsion as per law, but can be blocked by the department. And if such condition persists, the concerned officer may block the credit on GST portal. Once the input tax credit available as per electronic credit ledger is being blocked by the officer, cannot be utilized to set off against the liability or to get refunded. As per sub-rule 2 of Rule 86A, if the officer is of the opinion that such condition do not exist furthermore, then he may uplift such restriction and allow the credit available under electronic credit ledger. Further, sub-rule 3 of Rule 86A states that such restriction ceases to have effect after the expiry of 1 year from the date of imposition of such conditions. To elaborate this law further, we have 2 case laws. The first one is Krishna Fashion versus Union of India. In this case, Krishna Fashion is seeking for the release of provisionally attached bank account as well as unblocking of electronic credit ledger. In this case, it has been held by the Delhi High Court that the writ petition will be disposed of, and direction has been given to the department to defreeze the bank account as well as unblock the electronic credit ledger of the assessee within 3 working days. The second case is related to Advent India P Advisors Private Limited versus Union of India, having jurisdiction in Bombay High Court. In this case, the company is seeking for the unblocking of credit of electronic credit ledger as per Rule 86A sub-rule 3. In this case, it has been held by the Bombay High Court that as per sub-rule 3 of Rule 86A, if the period of 1 year has been expired after the imposition of such restriction, then such condition should be uplifted irrespective of the fact whether company has been cooperative during the proceeding or not. Further, it has been said by the court that department cannot take this plea that the reply is awaited from the petitioner's side, and until the submission of such reply, the restriction over electronic credit ledger will be continued. Hence, in this case, it has been concluded by the court that this petition will be disposed of. On the basis of discussed case laws of Bombay High Court as well as Delhi High Court, along with the wordings of Rule 86A Sub Rule 3, if a person is aggrieved with the decision of the department for credit being blocked by the Department of Electronic Credit Ledger, then he may take the benefit of the discussed provisions along with the case laws to file an application in the department against such blocking of credit if the same has been blocked for more than 1 year. This is all about credit being blocked by department. If you have any doubt, you can comment below or contact us in the information mentioned in description box. For more such informative video, subscribe to ASC Group. Thank you.